Hey gang, Massad Ayoob here for Wilson Combat, answering viewer questions, one of which is, can my training in use of force or self-defense be held against me in court? Well, if it's going to be held against me, I want to train with Scarlett Johansson, because the idea of Scarlett Johansson being held against me, oh, never mind. Seriously, can they bring it up? Yeah, of course, they can bring up anything. I would be thrilled if they did. But in my case, they won't, because if I'm the one on trial, we're going to be bringing it up first. I've been an expert witness for the court since 1979. We are, by and large, winning these cases. And we're winning them largely with a two-pronged strategy, showing that the defendant did what he or she was trained to do, and showing that what he or she was trained to do was, in fact, the right thing to do. That it was within what the courts call the common custom and practice for dealing with that particular type of life-threatening emergency. And ideally, we'll show that you acted to, another buzzword of the courts, best practices. I would want from the beginning, from the opening statement of the defense, for my training to come up. The reason this training element works so well for the trained defender is that the jury of your peers is not going to happen. Jury selection, which is really jury deselection, allows the other side to screen out anyone who has anything like your knowledge of firearms, criminal attack, self-defense protocols, and things of that nature. And they're trying to get a jury of a dozen lightweight yuppies from the suburbs who will be subject to their bamboozlement. The standard is, what would a reasonable person have done in the same situation, knowing what the defendant knew? Now, that's a three-pronged test. What would the reasonable, prudent person have done? The individual who exercises logic and caution. Prong two, in the exact same situation, not some BS that opposing counsel fabricated out of whole cloth, but the situation that the facts and evidence, the testimony and evidence show you were facing at the time you reached for that weapon. And the third critical prong of that three-pronged test, knowing what the defendant knew. And that doesn't cover just the seconds and moments prior to the shooting. It goes all the way back to your decision to be an armed citizen in the first place. But that third element of the test opens the door and allows your instructors to come in and testify and establish that fact. You did what you were trained to do. What you were trained to do was, in fact, the right thing to do when you faced a deadly criminal assault. And basically, that is the roadmap for victory in a case of this type. Google will take you to an article I'd strongly urge you to read called Defending the Self-Defense Case. Defending the Self-Defense Case was written by attorney Lisa Steele, S-T-E-E-L-E. She wrote it for Champion, the publication of the National Association of Criminal Defense Lawyers. Now, Lisa Steele is generally recognized as the leading appellate attorney who specializes in self-defense cases that went wrong at the trial level and resulted in an unmeritorious conviction. She is writing that article for her peers, trial attorneys, telling them how to not screw up a perfectly good self-defense case by using the usual guilt mitigation strategies that they use for their usual guilty clients. She makes the point that the trained defendant is by far the easiest to defend. The training shows here was a person who knew what to do, who did what he or she did because it was what they were trained to do by the experts, and it's within that common custom and practice for dealing with that type of life-threatening crisis and self-defense, and ideally acted to best practices. The other thing is, if you're not trained, how do you know what the right thing is to do? If you haven't been trained in the legal elements of self-defense, how do you know what standards you're going to be judged by? It's certainly not going to be BS you got from anonymous internet ninjas selling a gun for them. If the question is whether or not you competently fired that shot, were you trained? Many of you out here have enough handgun training that your instructors can honestly say, my client is better trained than the average police officer. If you're alleging that my client made a mistake, any reasonable, prudent person with his level of training would have made the same mistake, and obviously he should be held harmless. Can they use the training against you? Sure. They'll try to say that you are obsessed with violence and you went to death camp to learn to be a more efficient gunman and crap like that. Be careful who you train with. Don't be doing kill a commie for mommy in the jungle urban warfare training unless you thought Walking Dead was a training film. But if you've taken responsible courses in armed citizen self-defense, every single one of your instructors now can come in and verify that and speak for you. There was a great law professor and a great judge named Irving Younger. Now, if one accepts that attorneys are sharks, Irving Younger was Jaws. He taught the baby sharks how to gobble up people like us on the witness stand. His most famous lecture was called The 10 Commandments of Cross-Examination, and the first point he made in that lecture was all cross-examination should be destructive. Now, in another of his lectures, Younger made a point that's always stuck with me, and through all these years in court, I've found to be true. Younger said, look, you've got to understand, the jury is 12 people and a couple of alternates who've been picked up from ordinary life and thrown into that jury box. They're going to be flooded with contradictory information, unfamiliar terminology, science and policies that they've never heard of. And average adult learning retention of things they merely hear as opposed to what they see, visual learning, or what they experience, experiential learning, can be as little as 14%. Younger said there are some jurisdictions where they're not even allowed to take notes. And he said if a jury hears something once from one person, they may or may not pick it up. But he said by the time a juror has heard the same thing from a second credible source, it's going to be on their radar screen. And Professor Younger said by the time they've heard the same thing a third time from a third credible source, no power on earth will convince them that it is not true. Well, we have you, hopefully telling your own story, and anybody who says the defendant should never take the stand has been defending altogether too many guilty people. In a self-defense shooting, it's what's called an affirmative defense. You've stipulated to the shooting, but you maintain your actions were correct. It's no longer a who done it. Everybody agrees, you done it. It's now a why did he or she do it? And if you think about it, only you can fully, truly explain that. But there's going to be you. There's going to be your instructor, perhaps an expert witness in the field who will testify, among other things, that your training is within that mainstream of common custom and practice for dealing with life-threatening self-defense emergencies. And now we've hit those 3 points. And that's what makes the trained person, in my experience, defensible in court. Now, total disclosure, my primary income is from teaching, and if that sounds self-serving, well, so be it. I continue my training, and if I'm the defendant, every bit of the training that I take every year is going to be on my side of that fight, as hopefully it will be on yours. I hope I've answered the questions. We at Wilson Combat want you to keep them coming. We've got a think tank here that covers a whole broad spectrum of shooting, of sport, and of self-defense. We're looking forward to hearing from you. Take care.